Mr. Hawbaker, do you want the lights up?
Yes, please.
Millie, lights up, please. Mr. Hawbaker.
Thank you, Robert. Okay, please report. Counsel. Good morning. Good morning. I don't have a show put on the wall. I just want to talk to you. First thing I want to do is thank you. I'm not going to have a chance to talk to you again. This is it for me. The state has the burden. We talked about that at the beginning. And it's important that they have the burden in a case as serious as this. You know, I think about it often. We kind of break you from your normal lives, your daily routine, to come here and do something as horrible as this. Horrible. There is no getting around it. There's no question that it is horrible. But the only question that had to be answered was, did Sterling die a terrible death for us? If that's the only question that you had to answer, the answer was yes. The answer is yes. You will finally be in charge. You weren't in charge of how the evidence came in. You weren't in charge of charging Ms. Harris. As you sit there and listen to Ms. Timmons talk, what is the difference between first-degree murder and child endangerment causing death? The argument that I heard is that they're one and the same. But that is not true. Iowa recognizes a distinction. We have a statute that says child endangerment causing death is a crime. We reserve the most infamous crime in the state of Iowa, first-degree murder, for the most violent acts, the most violent of people. We convict people of child endangerment causing death when they are negligent and willfully deprive them of care, which is exactly what happened in this case. Exactly what happened in this case. Now, I talked to you at the beginning that the rules are different in here. The rules in a criminal case are different than any other venue, any other task that you will have. And those rules were outlined by the judge. And the rules are on the pieces of paper before you. Just as Ms. Timmons did, I want to talk to you about a couple. Reasonable doubt means that a reasonable person will hesitate to act. I don't disagree with Ms. Timmons that deliberation is not necessarily hesitation, but the hesitation has to be in the proof and the evidence is there. They have charged Ms. Harris from May 1st of 2017 to August 30th of 2017. During that entire time that she had the intent to kill Sterling. There is no evidence of that. And the glaring hole in the state's case, is what happened after the early week of August to the last day that Sterling was alive. What happened? What proof is there of what happened? What proof is there of why it happened? And the why is what makes things a crime. In the absence of being able to understand the why, it's not a crime. It is just a horrible, horrible thing for Sterling. They have to answer the why. That is what's lacking in the state's case. They can prove child endangerment. I'll talk to you about that at the end. But there's no first-degree murder. Malice is what we're talking about. It's instruction number 18. Some of it was put up on that wall for you to look at. The entirety of that instruction is before you. And one thing you must understand is there is no such thing as murder in the state of Iowa in the absence of malice. It is the only crime that requires it. And the reason we required it is because we singled that out, that state of mind, that depraved state of mind for those particular people. That instruction says that malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another. And then it describes the hatred that you have to have. Then it describes the evil that you have to have. And then it describes not something just unlawful, but with an unlawful purpose. Purposeful. Where's the evil, the specific, that mindset, that state of mind? Where's the state of mind of hatred? Where's the state of mind of that purpose? It does not exist. It does not exist. There's no proof of it. It's conjecture. And it starts from the very beginning of this case, which is you put up a horrible picture of a young child and you want that emotional response to overwhelm logic. But in Iowa, there's a crime for that. That's the child endangered one. It's not murder. There's no proof of malice. The last paragraph of that instruction that's before you says malice aforethought is a fixed purpose or design to do that harm. A fixed purpose or design. There is no proof of a fixed purpose or design for this happening. Yes, malice can be inferred by the commission of child endangerment, but it doesn't have to be. Instruction number 19 says malice may, but need not be inferred. And the reason that need not be inferred is because there are forms of child endangerment where there is no malice. If so, why even have the malice in there? Because all we have to do is prove child endangerment. But it's a recognition that there are certain things that can lead to a child's death that are not malicious, like the willful deprivation of critical care. Willful deprivation of critical care. The other thing to be aware of in these rules is that there are two forms of child endangerment that we're talking about in this one. One is the one that the state's attempting to prove to get you to first-degree murder. The second is the one in count 2. The first one requires the use of torture. Requires the use of cruelty. Use, act, towards, Sterling, requires the use. The second one, which is more appropriate for this case, says the defendant willfully deprived. And you can stand up and talk about every time they turned on the TV, every time you turned on the fan, every time you open the door and say, that's an act, that's an act, that's an act. And it's equally true that every time that happened, it was the willful deprivation of that care. Was it an act towards Sterling? No. It was a willful deprivation of that care, which is child endangerment causing death. If Miss Harris had a fixed purpose or design, if Miss Harris had the evil and the hatred that is required for there to be a murder, beginning on May 1st and ending on August 30th, there would have never been a need for a babysitter. There would have never been a need for a notebook. There would have never been a need for going to the Wapsie days. None of that would have happened. She had complete control over Sterling. She and Zach Cohen. You didn't have to take him to anything. He could have just died. It could have happened earlier. But at that time, and at no time, was it proven that she had a fixed purpose or design to kill Sterling. If, and this is the odd one, a hard one to wrap your head around. If she had that fixed purpose and design, if she had that desire to have Sterling dead, and was not simply just willfully depriving him of the food, why on earth, during the week that Sterling is found dead, on that Wednesday, was she making plans with her mother to take both the children that week? What that shows you, folks, is that it's not evil. It's not hatred. She was ill. Because that's delusion. Because we all know the status of Sterling at that point. We all know the status. That's delusion.
Based on our off the record discussion. Mr. Hawbaker, let's just move on.
All right, thank you, Your Honor. The evidence shows from Dr. O'Hara and Dr. Denner really did disagree that Ms. Harris was depressed or suffering from major depression at that time, and that's really what happened at the end of August. Otherwise, all the activities that happened in May, and June, and July, and the activities of babysitters and notebook and things like that make no sense. Make no sense. Nala, the fact that she at least was fed is easily explained by the testimony of Dr. Klein and also the testimony of Dr. O'Hara, and ultimately just by common sense. It makes sense that obviously Sterling only had one mechanism to attempt to survive, whereas Nala had the ability to approach her mother, to be demanding on her, to make sure that those needs were met. But have no illusion that the condition of that household was some sort of pristine and wonderful family environment. They were only in that apartment for just a little bit, and you can look at the condition of it. It's not in great shape. The status of the furniture and what little food they had in there isn't really something that you're going to find in most households. So this was not a wonderful environment. As shown by Dr. O'Hara, was not of the belief that Nala was necessarily in wonderful condition, if not physically, mentally. So the fact that she is here does not prove or turn the issue that it must have been some sort of focused attention on Sterling, when there are really no facts to support that. What's important is the idea that Miss Harris is not taking responsibility. That is not true. That is not true. When she was interviewed by Dr. Denner and by Dr. O'Hara, both of them, she's incarcerated, both of them, she's reflective, and at that point, Scribe is sober now, and no longer suffering from that major depressive episode that happened in August of 2017. She looks back at what was happening in that era and realizes, I was really messed up. I was really messed up. And we are not disputing that. She was really messed up. And because she was really messed up, and because of the choices that she made, because she did willfully deprive Sterling of critical care, we are not arguing her. The facts of this case support a conviction for count 2. Read it. It's exactly what happened in this case. We accept responsibility for that conviction. That's what happened. When people know that they've done wrong, they like to feel that there's been a balance, that they pay for what the wrong that they did. We accept the conviction for count 2. The reason that we're here, and the reason that we've taken a week and a half out of your life, is because it is not murder. The acceptance of responsibility requires, and Ms. Harris accepts, the conviction for child endangerment causing death. Justice, the finding of truth, requires the finding of not guilty for murder in the first degree, because there is no murder without malice. Thank you.